You say you haven't been the same since you had your little crash, but you might feel better if they gave you some cash. The more I think about it, old Billy was right. Let's kill all the lawyers, kill them alive. You don't want to work, you want to live like a kid.
Hey, John Mark.
Is it good to be alive and be in Tennessee
Ain't it good
today?
to be alive and be in Tennessee?
Just didn't
I'm
know after.
struggling.
I just didn't know after
I'm
last
struggling.
night.
I'm struggling. It's late night for me
Scar
last
tissue,
night.
you.
Broke my heart last
What you
night.
thought about it?
You
But,
would think I would learn by now.
Here we are
Did not
again
reply.
for what are we here for?
We're here for 2 marks and
Or 2 marks, 1 mic.
2 marks, comma,
One
1
mic.
mic. You got to
We're
put the comma in there.
going to get it right eventually.
We're on YouTube now.
Yeah, fantastic.
All of our podcasts are on YouTube.
It's
So
fantastic.
check them out. You know, I think this might be our 10th one too.
That's-
So happy anniversary.
Happy anniversary.
Happy anniversary.
So the last few episodes, we've talked about the court system, General Sessions Court, that we refer to as People's Court, and then Circuit Court, which is really the court of law, and then
Right.
Chancery Court, a court of equity. So let's not the system that people really appear in very
Right.
often, but
Right.
something that I think that when people hear about the law on TV, really and truly they hear more about Supreme Court cases than they do some trial level court case, even though they hear about both. So let's kind of talk about the appellate
Well,
system in Tennessee.
You got the Court of Appeals, right? That's a federal level. You got district courts. District courts and federal courts appeal to the Court of Appeals, and there's some circuits. How many circuits are
Well,
there?
so first of all, people understand, there are really 2 systems in every state. There's a state court system,
Right.
which is what we've been talking about, and that is Sessions Court, Circuit Court, Chancery Court, then our appellate court system, and then our Tennessee Supreme Court.
Right.
And then there's a federal system where what you just referred to, the district courts. There's 13 districts
Right.
throughout the country, and then the appellate court system for our district. We're in the 6th Circuit.
Right.
So any appeals in our area go to Cincinnati.
Right.
And then there's the Supreme Court, which
Right.
is the one we typically think of as the Big Daddy, and
Right.
that's in Washington D.C.
And that is the big daddy.
Yeah,
I mean, I think for a trial lawyer, do you think trial lawyers, that would be the pinnacle of their career, to be able
Yes.
to argue a case before the Supreme Court? And they probably have 7,000 to 9,000 filings a year.
Right.
And then it takes 4 justices out of the 9 to decide to hear an appeal.
Right.
You know, and they issue cert, right? It's
Right.
called cert. And then the attorneys get together and they brief the cases and they appear before the 9 justices in Washington, D.C. The Supreme Court is what you hear about on the high level civil rights cases, voting rights cases, sexual discrimination cases, Roe v. Wade. You always hear about Roe v. Wade,
Right.
how that was overturned. So, the Supreme Court entertains issues of federal law and constitutional law.
Yeah, so the way this system kind of works is, for example, if you have a case in the state system and you have a trial, say over in circuit court, say you have a car wreck, or it could be any kind of case, and the jury comes back and hands down, its verdict, whether it's a defense verdict or a plaintiff's verdict, you have the right to appeal.
Mhm.
You can file an
Right.
appeal in Tennessee with the appellate courts. Just because you have the right to appeal does not mean the Court of Appeals is necessarily
Right.
going to do what you want.
Right.
Actually
Yeah.
take the case and hear
Right.
it and let you argue. There has to be some basis for the appeal. There has to be some error that was made that impacts the way the decision came down. It could have
Right.
impacted it,
Right.
whether they will hear it or
Yeah.
not. So that's kind of the state system. It'll go from the Court of Appeals to the Tennessee Supreme Court. Similarly, in the federal system, you could try that
Right.
same case if certain requirements were met, diversity of citizenship, or if it's a question of federal law, you would file that case could be heard in the federal district court.
Yeah.
And the appeal from there goes to the appeals court in Cincinnati, and then if you appeal from that to the Tennessee to the United States Supreme
Right.
Court.
Yeah. I mean, all these procedures, all these cases, all these laws, the heavy docket, and in front of the Supreme Court, as we sit here today, is a lawsuit that Brother Jack Daniels brought against a manufacturer of a dog toy. Now there is a federal law. It's called the Lanham Act, and that would be an issue where you would file in district court because
Right.
it's a federal law.
Right.
And the Lanham Act protects the trademarks
Right.
of companies. And if a company feels like their trademark has been infringed upon, or it could cause confusion with the consumers, they can file an action under the Lanham Act, and that's what Jack Daniels did. That's what Brother Jack did. They filed an action in district court. They were successful in district court. They appealed it to the Court of Appeals. The Court of Appeals said, no, this is more of a joke.
A parody.
A parody.
Uh-huh.
And parody is covered under the First Amendment,
Right.
freedom of speech. And so the Court of Appeals said no, it's a parody, and because there was a difference of opinion between the courts in the federal level, the Supreme Court has got to make the final
Right.
determination about whether or not this is a parody or does it actually infringe upon the trademark of Jack Daniels.
And just to add to another level of confusion, you could start a case in a state Supreme
Right.
Court. In a state court system based upon a federal question, and suppose it doesn't get removed to federal district court. You could go through the state
Yeah.
system and ultimately the Tennessee Supreme Court, for example. And if it's a federal question, there could ultimately be appeal from the state system to the federal appellate system if the Supreme Court so wanted to hear the case. So just to add a little bit of confusion, but
All that being said, the Supremes, very, very busy, are now trying to determine whether or not this chew toy infringes upon the trademark of Jack Daniels. Now, the first thing you notice, of course, is the shape and size of the bottles. They are the same shape and size. So that does kind of infringe upon the design of the Jack Daniels product. Then this is called Bad Spaniels. What's that called?
this is called Jack Daniels.
Not Bad Spaniels, Jack Daniels. This says Bad Spaniels, the old number 2. What's that say?
This is old number 7.
The old number 7. So does that confuse you? Because the old number 2, it says on your Tennessee carpet. What does that say?
This is just Tennessee Sour Mash Whiskey.
Exactly. So the old number, so Jack Daniels is saying that the old number 2, what this company is infringing upon, is implying that their whiskey tastes like dog poo. Basically what they're saying. They're saying.
And I can vouch that it does not.
And this label says 43% poo by volume. What does that label say?
This says, of course, 40% alcohol by volume.
And this says 100% smelly. What does that say?
80 proof.
That's it, 80 proof. 80 proof. So they've played off as a parody, the label and the design and shape of this of this bottle. And the issue before the Supreme Court is whether or not this is protected free speech. The issue before the United States Supreme Court, where their lawyers have probably spent hundreds of thousands of dollars to get there, right?
I'm sure.
I mean, Jack
If not more.
Daniels, you're paying by the hour, right?
Well, you
Just
gotta
a whole
understand-
slew of lawyers.
You got to understand, Jack Daniels trying to protect its trademark, protecting its image. You can certainly understand why they may want to fight something like this, but it's going to boil down to
What do you think?
Well, it's going to boil down to where it's going to confuse the consumer. For example, if another whiskey company came up and was actually using this bottle,
Right.
this type of shape,
Yes.
this similar label,
All right.
then Jack Daniels
Yeah.
would probably be a slam dunk. The issue here, because what you would be doing is
Do you buy Jack Daniels at PetSmart?
No, I think, but
You buy this at PetSmart, right?
That's exactly right. So
Do you buy this at a liquor store?
You might. I don't know.
I'm not sure what liquor store you go to, John Mark, that sells chew toys.
Well, the point is, if it's likely to confuse the consumer, in other words, if a whiskey distillery
Right.
used the same type of label
I
in the
agree.
bottle,
I agree.
Jack Daniels
I
has a slam
agree.
dunk.
I-
The interesting issue here is using the same
Yeah.
shape and similar type design. Obviously, it's not whiskey. Is it going to confuse the consumer? Is this a parody or a joke? I think that's what it's going to boil down to, and we'll see what the Supreme Court's going to say.
The same company has done something with a Mountain Dew bottle. Mountain Dew. It's called Mountain Poo. All right. However, Mountain Dew did not sue this company over Mountain Poo.
Right.
You know why? Get over it, man. Get over it. It's a parody. It's a joke.
Right.
Have a sense of humor.
Well,
The major difference between this and Jack Daniels right there is that you can pour Jack Daniels into a cup, into a glass, and we're going to celebrate our 10th. Is that enough?
Yeah, that's
This is to our 10th episode of Two Marks and One Mic.
or 2 marks, 1 mic.
Cheers.
Cheers. Thank you, guys.
That's good.